Hey everyone, I'm Leland Fox, aka Fickle Father, for my purposes of being online. But I'm going to go over the Disney versus DeSantis case today. I'm really just going to give you an overview of what the case is about. We'll talk about the parties first, and then I'll go into some of the details. So, this is my very first video, and I've been trying to record this about a million times, so I'm just going to go into it and see what happens. I'm going to try and not be too long winded here. But the easiest way to think about this case, in my opinion, is to think of it as like basically an HOA dispute, where Disney World is on an HOA, which is called a special improvement district. But it's an HOA that has an HOA board, and the board decides what happens within the HOA area. And this was a hostile takeover by DeSantis and the Florida government of the HOA board. They took it over. And Disney is saying, "Hey, you took it over because we spoke out against a law, which in the media was called the Don't Say Gay Act, but in Florida it was called the Parental Rights and Education Act." And DeSantis didn't like that Disney got involved in that legislation, and so uh, what Disney is saying is your takeover of this board is retaliation for us exercising our First Amendment rights to the freedom of speech. And that's wrong. And what DeSantis is going to say is basically, yeah, we didn't like you interrupting or getting involved. You can say whatever you want, but you got involved. And since you got involved, we started looking at, what's going on here. And we found that this whole special arrangement where you're you control the board of your own HOA and decide what happens within this property without control is against the Florida Constitution. And so we're looking at this and saying we need to fix it. And so all we're doing is fixing special treatment that wasn't allowed under Florida law to begin with. And that's kind of what the case is about. So with that, let's get into it. I'm first going to look at the parties here. Of course, Disney is the plaintiff. DeSantis is the first named defendant. And something, an interesting fact I learned about him and doing the research on this case is that he played baseball at Yale as an undergrad student. He was the captain of the baseball team, and I guess he was also the best hitter. Didn't know that. The second named defendant is Meredith Ivy, and she's named as a defendant because she is the acting secretary of the Florida Department of Economic Opportunity, or the DEO. And the DEO actually oversees all of the special districts in Florida, including the special district where Disney World sits. But she's really not going to she's not mentioned anywhere else in the complaint other than as a party. And then the next defendants are all part of the board of what I'm referring to as the HOA, or the special district. It was called the Reedy Creek Improvement District, and now it's called the Central Florida Tourism Oversight Board. So these defendants are all members of the board. And the first one here is Martin Garcia. He's the chair of the board. He is basically a real estate investor, runs a investment company called Pine Hill Capital Partners with his sons. It's kind of a family thing. The next two are attorneys. The first one here is was Brian Ongst Jr. Brian Ongst Sr., I guess, was a mayor in Clearwater, Florida, and was credited with really turning things around there and improving Clearwater. So he's got some name recognition, I would assume, in the Florida area. And then the other one is Michael Sasso. I actually don't know much about him other than he was a partner in a law firm with his father. That's really what I know about him. The next one here is Ron Perry. Ron Perry, I would consider himself a Christian minister first. He runs his own ministry, which he calls The Gathering. It's an online thing, and it has been criticized for having some, I guess I would say, far right views on homosexuality. things like that. But he started a software company that did reservations for airlines, and he sold that. He started it in 1997, and he sold it in 2019 for 110 million. So he's done well. And then the last one here, the last name defendant, is Bridget Ziegler or Ziegler. I'm not sure how to say her last name. But a Bloomberg podcast called her the queen of the school board queen. And what she does is she, I guess, trains conservatives to take school board positions, and then they can kind of control what happens in the schools and with the policies from there. So that's the board members that DeSantis put in when Reedy Creek Improvement District was changed to the CFTOD, or the Central Florida Tourism Oversight District. And they're the defendants. And then the last name defendant is John Classy. And John Classy was the administrator of the Reedy Creek Improvement District, again, before it was changed to the CFTOD. And he had been in that position for a while. And he's, I think, a really interesting defendant because I think he was probably, out of all these people, except for maybe Meredith Ivey, she probably didn't have much to do with this, but he's definitely seems to be caught in the crosshairs of all of this political mumbo jumbo. And he's no longer the administrator. And my understanding is he's trying to work out a different position for himself, still with the district, but they're not going to keep him on as the administrator. They're getting their own people in. But he's a defendant, and interestingly enough, when we talk about getting into more of the details, he's going to have a role in that, and so he'd be an interesting witness, I think, and we'll see what happens with that. But those are the parties to the case, and let's get into it here. Again, this is a special improvement district called the Reedy Creek Improvement District. I think of it as an HOA, but it straddles Orange and Osceola County in Florida. And Disney is the largest landowner there. And the way that the board is determined is you get 1 vote per acre of land that you own. And since Disney owns it all, they get all the votes. So they decide who is on the board of Reedy Creek Improvement District. And then the district oversees basically all the infrastructure, the development, and things like that of the area. And so they could control what happened with the development, with the management of the area, and things of that nature. So what happened was Florida was considering the Parental Rights and Education Act, and that got a lot of attention in the media. It was called the Don't Say Gay Act, and you probably heard the news if you were watching the news, but the most controversial talked about part of that act was this, where it said classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. And there was a lot of criticism about that, but the main thing was that it became known as the Don't Say Gay Act, and Disney employees didn't like it. They put a lot of pressure on the then CEO, who was Bob Chapek. They wanted him to take a stand and say, hey, they're saying you can't say anything about, gay in Florida. This is wrong. Please take a position. And he seemed to be somewhat reluctant in doing so. He ultimately did send out a memo internally to Disney, basically saying, hey, we're we believe in being, well, let's see, let me pull it up here. We continue to work towards a more inclusive, tolerant, and respectful world is basically what he said, but he wouldn't condemn the legislation. And so that wasn't well received at Disney and in other places in the media. They wanted Disney to take a stronger stand, and they kind of did that on social media. On the Disney Parks Facebook page, they made a stronger statement saying, to all who come to this happy place, welcome. Disney Parks experiences and products committed to creating experiences that support family values for every family and will not stand for discrimination in any form. We oppose any legislation that infringes on basic human rights and stand in solidarity and support our LGBTQIA plus cast, crew, and Imagineers and fans who make their voices heard today and every day. So that was their public statement on social media. Well, DeSantis saw that, of course, and he didn't like it. And let me see if I can pull up the video of what he had to say to that. I'm going to try this, and this might get a little messy. I'm warning you here. Okay, that clip did not work, so I'm trying here again. Hopefully this one works. Asking about Disney and deciding to go.
Well, look, all I would tell people is, read the bill. And if you have issues with it, articulate those. It's a free country. But, what I don't do are narratives and slogans and people just putting things out
He
that
does
are
do that.
basically false narratives. And I think that's what happened. I think, unfortunately, Disney's leadership bought into a lot of the false narratives. But I think when you're looking at saying, for our kindergartners, our first graders, our second graders, the classroom instruction they're getting should not be involving, these issues involving sexuality, particularly things like transgenderism, where they're being taught that they may be able to change genders. That's something that parents do not want. That's something that a parent would want to be engaging with their student in. And so I would just tell people it's a free country. Do what you believe in, but understand if you are out protesting this bill, you are by definition putting yourself in favor of injecting sexual instruction to 5, 6, and 7-year-old kids. I think most people think that's wrong. I think parents especially think that's wrong.
Yeah, so the point here is that DeSantis didn't like that Disney was getting involved in this legislation. And as he mentioned in this conference, he was going to be signing the bill, which he did. The bill was put into law. The Don't Say Gay Act, and he also didn't like that people were calling it the Don't Say Gay bill, because he would say that's not what it is. It's the Parental Rights and Education Act. We're giving the rights to the parents to teach their children about these things and keeping them out of the schools. But anyway, so that was kind of a hot button for him, in my view. But after the legislation was enacted, Disney made a more official statement on their website, and which says the following statement may be attributed to a spokesperson for the Walt Disney Company. Well, so maybe I'm saying, I don't know if they're saying, anyway, this was what Disney, this was on their website. Whoops. Florida's House Bill 1557, also known as the Don't Say Gay bill. Again, I think DeSantis is seeing them say that, and then he's thinking, well, that's not what it is. Anyway, should never have passed and should never have been signed into law. Our goal as a company is for this law to be repealed by the legislature or struck down in the courts, and we remain committed to supporting the national and state organizations working to achieve that. We are dedicated to standing up for the rights and safety of LGBTQ plus members of the Disney family, as well as the LGBTQ plus community in Florida and across the country. Excuse me. So they now Disney comes in and says, "Hey, DeSantis, your Don't Say Gay bill, we're going to try and get it repealed." And so, obviously, he didn't like that. And I don't have these clips because this was in different press releases and things of that nature. But he did say in a press conference, I think they crossed the line. We're going to make sure we're fighting back when people are threatening our parents and threatening our kids. He wrote a book about it. And he said that when Disney put out this statement, that this was a declaration of war. His press secretary issued a statement saying, "Go woke, go broke," which is a slogan that DeSantis says he doesn't do. But anyway. And then DeSantis announced that Florida is the state where woke goes to die. And again, he was just upset that Disney was doing this, upset that Disney was getting involved, was crossing him. I think he was upset that Disney was caught up in this, in calling it the "Don't Say Gay" bill instead of calling it what in his mind it actually was. And on this point, I don't want, this case isn't about whether the legislation was right or wrong. The "Don't Say Gay" or Parental Rights Act. The point here is that Disney did make a statement about it, and it upset DeSantis. And so then what Disney is saying is that from that point on, DeSantis retaliated against Disney for them exercising their right to speech and opposing this legislation. And that is kind of what happened in my view. But what happened was then DeSantis went and looked at the Florida Constitution, and he found a hook that he needed to kind of whack Disney across the head with. And in the Florida Constitution, it says, there shall be no special law or general law of local application pertaining to private incorporation or a grant of privilege to a private corporation. And so he's looking at that and says, hey, wait a minute. The Constitution says you can't grant privilege to a private corporation. You can't have a law that does that. And this special district, which Disney can control its own, HOA and decide everything that happens in there, that sure seems like a grant of privilege to a private corporation. And so he asked the Florida legislature to take a look at it. He wrote a proclamation to the legislature, says, and I'm skipping around here, but anyway, he says the Florida Constitution of 1968, and importantly, Reedy Creek was enacted in 1967, so which was before this amended Florida Constitution went into effect, which had this provision. So he's looking at it and saying, hey, okay, so the Florida Constitution of 1968 generally disfavors special laws as opposed to general laws, but permits the creation of independent special districts that appropriately serve the public interest. So he's saying you can have special districts that serve the public interest. But he says Article 3, Section 11A12, which was the one we just read, prohibits special laws granting privileges to private corporations. So he says independent special districts exist that were established prior to the amended Constitution being ratified in 1968 that have not been reestablished, ratified, or otherwise reconstituted by a special act or general law after the amended Constitution was ratified. So he says it's necessary to review such independent special districts to ensure that they are appropriately serving the public interest. And then there were some other things he wanted to review in relation to social media. But anyway, so that's what it was. That's the way DeSantis saw, hey, I can go after Disney in this way by attacking their special district, which may be unconstitutional according to the Florida Constitution as amended in 1968. So he called a special session of legislature. He says that to call the legislature of state of Florida for the special session to expand. That's a terrible reading. It says the purpose of the proclamation is to call the legislature of the state of Florida for the special session. I'm doing it again. Anyway, the point is he had a special session of legislation so that they can consider legislation relating to independent special districts, aka this Disney district. And that's exactly what the legislature did. The same day that he made this proclamation, Representative Randy Fine of Florida introduced a House bill, but it was the same as the Senate bill that ultimately passed. And in it, they said any independent special district, which again is Reedy Creek, established by a special act prior to the date of the ratification of the Florida Constitution in 1968, and which was not reestablished, re-ratified, or otherwise reconstituted by a special act or general law after the Constitution, is dissolved effective June 1, 2023. So about a year after this SB4C. So really, this impacted 6 special districts that were created before 1968, but only one of them, according to Disney's complaint, had any sort of connection to a private corporation, which was Disney. And so anyway, so this is how they were going to end up dissolving Reedy Creek in June 2023, because there's no way Disney was going to go say, hey, reestablish and re-ratify it as is. So it was going to be dissolved. And I'm sure Disney was looking at this and saying, well, shoot, how do we maintain control of our HOA given this SB4C passing? And so when that happened, Randy Fine put out a tweet. So not when it was passed, when it was introduced. He said, Disney is a guest in Florida. Today we remind them. Governor DeSantis just expanded the special session so I could file House Bill 3C, which was the same as Senate Bill 4C, which was one that ultimately passed, which eliminates Reedy Creek Improvement District, a 50-year-old special statute that makes Disney exempt from laws faced by regular Floridians. And so what they're looking at this, the way they're looking at this is they're saying there was this unconstitutional law that gave Disney special privilege, and we are just going in and we're removing that privilege so that they're treated just like every other corporation that exists in Florida. Whether or not that's true, I don't know, but that's what their argument is. And so Disney, of course, pulls this out and pulls all the things that DeSantis has said, criticizing their involvement, and says this is obvious that they are targeting us to dissolve our special district, because I mean this would have never happened if we didn't speak out against the Don't Say Gay law. And they're probably right. So what Disney did in response is they said, okay, well, shoot, our district is going to be dissolved June 1, 2023. And then some, time went by since this passed, and this passed in the spring of 2022, the bill dissolving the special district. But Disney looked at it and said, well, what are we going to do? How are we going to maintain control? And what they did was they entered into some development agreements and restrictive agreements with Reedy Creek before it was dissolved. And I'm sure, had caught wind that DeSantis ultimately wasn't going to let it dissolve. And, the reason being is if it dissolves, then the special district gets absorbed into those counties. And then the counties would end up taking on all the debts and obligations that were the special districts. And everyone was kind of freaking out about that. So he says, I'm not going to let it dissolve. I'm going to keep all of the agreements in place. And basically what I'm going to do is rename it and put my own people in. That was a rumor that Disney was hearing, I'm sure. So anyway, what happens is that Disney enters into these agreements with the Reedy Creek as it still existed. And again, so you go back, and it's John Classy, the defendant from before, and I'm going to scroll back up to him. John Classy is the administrator for Reedy Creek. So they're meeting with him, and they're going over their plans for development for the next 10-something years and saying, we're going to lock this in. We're going to make an agreement that basically allows us to do all the things we would have wanted to do if DeSantis didn't come and take in all his people. And so we'll have these agreements in place. So when the new board comes in, they'll be locked into these agreements. And so you can see here, I just pulled these out from the contracts. It was signed by Disney by John McGowan, and it was signed by Reedy Creek Improvement District by John Classy there. So as you can imagine, in the news, it basically said, DeSantis is trying to pull a fast one on Disney, and they get the last laugh because when his new people come in, they're subject to these contracts. And DeSantis didn't like that. So not only did he say, I'm putting my people in there, And when my people get in there, we can do whatever we want. Basically, we can raise taxes on hotels. We can put tolls on roads. Maybe we'll put in our own park, amusement park. Or, you know what? I think we could use a prison in that area. Those are things that he said, and so he's kind of lashing out here. But one way he does it is he sends an instruction to the chief inspector general saying, "Hey, these contracts, this is Disney trying to collude to undermine what we're trying to do as a legislature by locking in these contracts. And so, Inspector General, I want you to go in and investigate Disney, investigate all the Reedy Creek people, and if you see anything that looks foul, I want you to report it to the appropriate authorities." Kind of basically is threatening, criminal or civil retribution for Disney doing what it did with these contracts. And with this letter and these threats, that's when Disney filed their lawsuit. And they said, "Hey, we didn't want it to get to this, but we're filing a lawsuit because we are being retaliated and attacked with the full powers of the government because we took a stand on the law." And that's basically what Disney's complaint is about. Okay, so they filed their lawsuit, naming all these people we've gone over. But that's the basic background of the Disney versus DeSantis case. And yeah, I'm gonna leave it at that for now. What has happened since the filing of this lawsuit is the new board, the CFTOD, filed their own lawsuit in Florida state court. Disney filed in federal court. And basically, DeSantis is saying that Disney is forum shopping. They're getting this in front of a judge that doesn't like DeSantis. And they think he thinks, yeah, maybe this judge will rule in Disney's favor. But what they're going to do is go into state court. And one problem with Disney's complaint, in my mind, is that all of their claims rely on these contracts that they entered into with John Classy. It relies on them being valid and enforceable contracts. And then, an important part, I guess I should add to this, is that what DeSantis did in once these contracts were there is they voided the contracts. They said these contracts are void and enacted some legislation, and they said they're void for various procedural flaws in the enactment of the contracts. And they may be right on that, but again, with Disney's lawsuits basically require that these contracts be valid and enforceable. And so what the board is going to do is go into state court and say, "Hey, state court, we need you to rule that these contracts are not valid, because if you rule that these contracts are not valid and Disney's federal case is all relies on them being valid, then their federal case goes away because all the things that they're asking for go away." And that's not totally true, but largely true. Disney only has one claim that doesn't relate to the contracts. But I'm going to look at the complaint in more detail along with the board's complaint in state court kind of together, so we can compare all the claims and see how they're going to interact, because it's going to be really interesting. There's basically going to be a little bit of a battle on which court's going to be able to hear the case first or at all. So that's just the case. If you want to stay tuned, please subscribe to my channel, and I'll be covering this case, and I have a few more other interesting cases that I'm going to be following along as well. But my hope here is that as we follow along these cases, it's just going to be fascinating to see lawyers do their thing, and I'm going to be talking about what I think might be going on in the background here. I'm a civil litigation attorney. I've been doing it for over 12 years. I had my own practice. I've practiced with a small firm. I've practiced in a government interest group. And now I'm an in-house attorney at a major corporation. So I hope you'll follow along, and I think it's going to be interesting. And please subscribe, and I hope to see you in the next video. Okay, thank you.